Hi, everyone. Thanks for joining us. My name is Stephen Lee, and I'm a lawyer in Chicago who's been practicing for more than 20 years. But like many of you, I started off not knowing much about the law. One way that I really learned about the law and how litigation actually works is by watching trials early in my career. In fact, during law school, I had the good fortune to sit through actually three criminal trials during and immediately after my law school education. And I learned a lot about how the law really works by watching those trials. And that's why I encourage people who are thinking about going to the law or young lawyers and law students to actually just go to court and just see what's going on there and see it for themselves. Federal courts, state courts, they're open to the public. And you can often just go there yourself and just see what's going on. Now, I recently had the good fortune to host two college students from Yale's Asian American Cultural Center to kind of shadow me for a week here in the spring of 2025. Yolanda Wang and Zhang. And when they were here, I took them to the federal courthouse and I showed them around. And we happened to pop into a federal courtroom just as a civil trial was about to start. And so they ended up watching a lot of the trial, and we had some really interesting discussions about that trial. And we thought it'd be helpful to share and share what they observed and to share kind of their observations as people, lay people who are seeing a trial unfold, and hearing from a lawyer who explains kind of his perspective on what's going on and what you're seeing and what they're not seeing behind the scenes. So first of all, so hopefully this is helpful for everyone, and we'll get started. So I think the way we're going to do it is, so Arrow and Yolanda, they were there. Like I said, they were there actually from the very beginning, even during jury selection. So they're going to go back and forth. They're going to explain what they observed, and then I'll comment as appropriate. So Arrow, why don't you get us started?
Yeah, first off was the jury selection. This was before we really knew anything about the case yet. There were a lot of juries sitting in the jury box, and then one by one they went up into the witness stand, put on their headsets. There's technology in the courtroom now. They put on headsets. The judge also had headsets on, and all the other attorneys and witnesses in the case. And the judge and the jury member were going in a back and forth, and you can tell it was a very thorough questioning process. After all of the jury members were questioned, the attorneys on both the plaintiff and defense sides got together, and then they brought up members that they thought should not be considered as jury members because they potentially have a lot of bias, and so they should just not be considered. And then the judge would either say, okay, sure, let's get them out, or the judge would overrule it and say, no, I think this jury member is fine to stay. Afterwards, each side also got three strikes, so they could strike out jury members that they thought they didn't want on the jury. Um, and the plaintiff attorney brought up the question of what if both sides struck the same jury member, to which the judge was like, then they strike the same jury member. And then we ended up with jury, eight jury members for the case.
Okay, so right. So ultimately, first of all, just to back up, this was a civil case. And so civil cases are handled differently than criminal cases in the federal system and in the state system. And so basically, but really, trials are what ultimately what's happening in a trial is that the parties who are actually litigating the case have not been able to work out a resolution. Because that's the thing. Judges would generally prefer cases settle one way or another without having to go to trial because trials take up a huge amount of resources and can ultimately drag on. And so if the parties can reach a resolution, that's kind of the best thing for at least the judicial system as a whole. So, but when a case goes to trial, it's really important to like get a fair jury to hear the case because basically both sides are putting a lot of work and both sides want a fair jury. And that's what jury selection is largely intended to accomplish. So what you do is you randomly get like, 30, 40, 50 people, sometimes many more from the community, and you pull them in for jury selection. And basically you go through this process called voir dire. And the process that Arrow was describing is the process to kind of determine who among these people would help represent a fair jury to hear this particular case. And as Arrow mentioned, it's kind of two parts. The first part is gathering information about the jurors to see if there's just some problem where it's like, look, this person just cannot, as a matter of law, be a juror on this particular case. Now, some reasons are pretty obvious. Let's say if it turned out that one potential juror was the best friend of one of the lawyers involved, well, that person probably should not be on the jury, and that person's stricken. There may also be things that are just make this person it's just improper. Like, for example, if the juror went through a similar life experience that's just very close, so close to what this trial is going to be about, that it's going to be hard for them to put that aside and hear this particular case. Again, that's someone that the parties or the judge might strike for cause, meaning, look, this person just can't be on this jury as a matter of law. Once that's done, that's when it goes to what Arrow was describing as the strikes or peremptory challenges. And that's where each side is basically left with, okay, here's a bunch of potential jurors who, as a matter of law, could be on this jury, but you can get rid of a certain number of them for basically any reason that is not violating the anti-discrimination laws. So, for example, you can say, look, this person just has like they could be fair, but they have specialized knowledge, and I'm just worried that they might not work. Get rid of them. It can be, you know what? I just have a bad vibe. I just don't like the way that person was looking at me or my client during jury selection, and I just don't want that person on the jury. That's a legitimate reason. You can't strike someone because of their race or their sex or things like that, but otherwise you can strike people based on your reasons. And the big thing about jury selection, especially in cases where it goes fast, because most jury selections goes fast, you're really just trying to strike people who you just have a problem with. It's not about crafting the perfect jury for you. It's more about getting rid of the people who you just think are probably going to be bad for you. Um, there are cases where jury selection is much more complex. You get a lot more information about jurors, but usually you're making decisions very fast. And so you really are just limited to just trying to strike people who you just, feel for one reason or another, just you'd rather not have on your jury. So, and once that process is done, that process takes some time. It can take a few hours. A day is not unusual. Then you have your jury, and then you move on to the next phase of the case, which Yolanda will talk about.
Yeah, so this was Monday of last week, and so after jury selection, we heard the opening statements from each side, and I believe it's the case for both criminal and civil trials that the plaintiffs or the prosecution will start first, and so since this is a civil case, it was the plaintiffs who started first. And this is where they kind of started to lay out the scene. The facts of the case were generally that this one family with a mother, a husband, and there are two children, one who is 4 years old and one who is 1 year old. They were driving from I believe they were staying with one of the parents' mother during COVID because their apartment had been undergoing renovations, and so they decided to drive and take their children, make it a family day to check up on their apartment renovations and also take their kids to the playground. And on their way, during this little road trip, there had also been a shooting at I think around 1 p.m. In Chicago on that day, and so at the same time, police officers in Chicago had been high alert for a potential murderer on the loose, and so enter officers G and Officer A, who had stopped the plaintiff's family on the road, and so the way it kind of went is that they were in a police van, and the police van was about 5 to 7 car lengths behind the plaintiff's car, and they had been following for quite a while before they started to turn on their lights at around I believe 35th Street, and then the plaintiff's family finally began to pull over I think around 39th Street, which I think both the plaintiffs and the defense agreed was about a mile after the officers initially turn on their lights. And so then the family pulled over and but then the police officers didn't treat this as a normal traffic stop. They immediately asked or after a few minutes of stopping, they asked the plaintiff's family to step out of the car with their hands raised, and they had started to point their guns at them. And slowly they asked the plaintiffs, like the mother and the father, to walk backwards slowly to the police car and where they handcuffed them. And then eventually, when the officers approached the car, they saw that the two small children were there. And so that's basically what the scene was, very generally. And so the plaintiffs started out their opening statements pretty strongly. The lawyer said police just don't point guns at people during traffic stops. And they repeated this multiple times throughout the opening statement. And they really did a good job to humanize the family. They established that the mother was actually from a whole family of police officers. I believe her father-in-law, her cousin, her sibling, multiple family members of hers were officers or police officers as well in Chicago. And that was something that came up later in the case when they were discussing like her reasoning for maybe not pulling over sooner, and they also talked about the mental distress that the family experienced with guns pointed at them and towards the car with their children in it. And they also talked about how the officers at the time, so Officer G was a field training officer, I believe, um, and Officer A was being trained by Officer G. And I believe the plaintiff's lawyer was kind of hinting at this and more thoroughly explained it later in their closing statement, but they kind of laid out that, oh, maybe Officer G took this as an excuse during the situation around the shooting to kind of use it as a teaching moment. But unfortunately for the plaintiffs, this teaching moment ended up in something that resulted in a lot of trauma for them. And so that's a summary of the plaintiff's opening.
So yeah, let's before we get on to the defense opening statement, let me just back up a little bit. So opening statements are how really kind of like for most cases, like really what the jury first hears about what the case is about. And each side gets to take a turn to explain, to tell the jury, this is what I think the evidence is going to show. And so they lay out things, they try to frame issues, they try to describe what's going to happen in this trial that now the jurors are now forced to sit there and basically listen to and rule on at the end. And so it's not supposed to be argumentative. It's supposed to be mostly just, I think the evidence will show this. But obviously, it does frame issues, and it's really important to set the tone for the trial and help determine well, like what issues are really at stake. So in this case, as Yolanda was describing, it really involves basically this whole incident that occurred in 2020 in Chicago, really involving the police stopping this one family, and whether or not it's whether the police's conduct during this stop was appropriate or whether it went too far. And that was the basic allegation the plaintiffs were saying that the police, whatever their intentions were, maybe at the beginning, when they pulled over, that things went too far and it violated the family's constitutional rights. And okay, so let's talk about the defense opening statement, and like I guess I'll probably give some thoughts about the case overall. But right, so then it goes on to the defense opening statement. So Yolanda, can you describe what you saw there?
Yeah, and so I think before I start, I guess it's probably important to talk about the three charges, or the three claims that were brought against the officers. So Officer G and Officer A, who were the ones initially making the traffic stop and pointing their guns at the plaintiff's family, the plaintiffs claimed that they had used unreasonably excessive force against the plaintiff's family and violated their constitutional rights. And then a third officer, Officer M, the claim against him was that he had conducted an illegal search of the plaintiff's family's car, and the facts were that it was very brief. He had stuck his head in for about 5 seconds or so, maybe a little longer, to search for keys in the car to start the car up again and turn on the heat because it was in December of 2020 and they thought it might have been cold for the baby. And so the plaintiffs were alleging that this constituted an illegal search. And so what the defense started off with was setting the scene from their perspective, which was, again, that a shooting had happened just about 15 or 30 minutes before the traffic stop had happened. And so all officers were kind of on high alert. They had heard over the dispatch a description of a white sedan with, I believe, damage to the back tires. And that was what was believed to be the getaway vehicle for the murder suspect in the shooting. And so around this point, a few minutes later, Officer G and A kind of phone into the dispatch and say, is there any call for, I believe, a blue or gray Nissan Altima with like bumper damage or something along those lines? And the dispatch had responded, no, we're looking for a white SUV with tire damage. But at that point, Officer G and A had made the call to make the stop anyways, and so they're like, we're pulling them over. And so what the defense was saying is that if you were in these officers' shoes, or if another reasonable officer were in Officer G and A's shoes, they probably also would have been kind of fearful at this time, driving in an area where a shooting had just occurred, being on the lookout for any car that might have been involved in that shooting. And when they decided to pull the plaintiff's family over, they were doing it under suspicion that there could be a murderer in that car, or there could be multiple people in that car harboring weapons, maybe threatening the police, shooting right back at them. And so they were entering this incident on high alert and very fearful. And so the thought process allegedly that went into the defendants pointing their guns at this car was that, well, if the car in their mind matched somewhat of the description and could potentially have dangerous people inside, then they need to go in with their guns out basically and to be ready for any altercation that might occur. And at that point, they had reported it to the dispatch as a pointing incident. Um, Upon when other officers heard, they just kind of came in for backup. And so I believe there were about 6 or 7 officers in total, about 15 minutes into the scene. And yeah, it was just a lot of confusion going on. That was what the defense was emphasizing. Yeah, there's a lot going on for the officers to think about. And all throughout the incident, they had been kind of running on adrenaline, but it was a reasonable, like fear that they were feeling. All their actions that stemmed from this fear and stemmed from the shooting that had set the mood prior. All those actions were reasonable, and they also kind of dug on the claim against Officer M, saying that this is just kind of a weak claim. I mean, he was just sticking his head into the car to look for keys and start the car for the baby. And I think they were arguing that this was some kind of community care exception under the relevant statutes and law about illegal searches. So overall, their claims were about how the officers were acting reasonably in a situation that could have been very dangerous for them. And again, they were emphasizing how officers are probably accustomed to a higher level of danger than most citizens are. And so they're probably going into an incident like this on higher alert than maybe someone from, like, maybe a civilian or whoever the plaintiffs were talking about might have gotten into the incident with.
Okay. Well, look, and that's kind of the point of the opening statements, because in a case like this, and in many cases, basically the two sides that most best know what actually happened, they can't agree on how to resolve the case. And a big part of that is, I think, because of an issue that it sounds like it didn't really come up in opening statements. And that's because a big part of the civil litigation and even criminal litigation, and that is like, is there a way to work it out? Is there some kind of, how do you actually resolve a case? And civil cases ultimately are about awarding money, damages. That's ultimately what a civil lawsuit's about. If you bring a civil lawsuit, ultimately you can maybe get some type of like what they call injunctive relief, things like that. But really what your most civil cases are about are seeking damages that the other side, the defendant, should pay to the plaintiffs. And I think that's really the big issue here. Because it does sound to me like, and I was a federal prosecutor and I worked with a lot of police officers, and it's traffic stops are dangerous situations. And I get it. I totally understand and sympathize with police officers. When they pull over a car, they don't know what's about to happen, and there are risks involved. And I totally understand that. So that's where there's a lot of merit to both sides' view, that both sides, there was definitely confusion, there was misunderstandings, there was definitely a mistake. Because obviously this family, to be clear, obviously this family had no involvement in that shooting. Okay, they were not. This was the wrong car. So the question is, but the big question about this is, what damages did the plaintiff family suffer, and how much should the city be ordered by the court to pay this family? Because that's really ultimately what this trial is really ultimately supposed to resolve. And one thing, that Yolanda and Arrow, when they told me about the case, we actually pulled up the public docket on the case, and we could tell from that there were some attempts to try to settle the case, because again, that's how usually most civil cases get resolved. And basically, it didn't. Those settlement discussions didn't really go very far, because the two sides were just so far apart. And my guess is that, and again, I'm not involved. I don't have any. All I know is kind of what's publicly available. But just knowing how these cases go, my guess is that the defendant was willing to pay some amount of money to the family in order to resolve the case. Not necessarily because the city's necessarily conceding that the officers did anything wrong, but also because to save money. Because look, going to trial costs a lot of money, especially if, preparing for trial, doing the trial, post-trial issues, that costs a lot of money. And, sometimes, a lot of times, someone who's sued will want to settle just to kind of have have this case resolved. But my guess is that the plaintiffs were asking for more money than the defendants were willing to pay. And that's why, and they were probably so far apart that that's why they couldn't really resolve the case through a settlement. And so that's kind of where we're at. And it sounds like that really didn't come up in opening statements. But that's really kind of the issue that probably was driving a lot of why this case was actually going to trial. Because it sounds like both sides there was merit to both sides' position, but they probably couldn't reach resolution on damages, on how much money should be paid to resolve the case. And that's something that kind of comes up later on. Okay, so that's opening statements. And that's kind of how so that all sets the scene for the jurors. So now they have some idea of what they're going to be told in the rest of the trial. And then basically, and I think that now we get to, then we get to the actual evidentiary part of the case, where both sides get to call witnesses. And Arrow is going to talk about the first witness who testified.
Yeah, so the first witness is Officer M. And as a reminder from the opening statements, Officers A and G were the ones who pulled up first, and the Officer M was one of the police officers who were called later on for backup. So this officer arrived later on in the scene. And most of the questioning was just laying the foundation for what the police usually do at some regular traffic stop. So they were asking questions about how far do you park behind the car? You park about one car length behind the car. And then you get out of the vehicle, you walk up to the car, you pull up at their window, walk up to their window, and you ask them for their driver's license, their registration, their insurance. And they're just establishing the standard procedure. And also, right before the officers start interacting with the person, they have these body-worn cameras with a button on top, which you press twice right before, and then you're supposed to have the interaction recorded. And it was great that they had Officer M testify first, because his testimony allowed us to really put into perspective what a standard traffic stop should look like, and then what absolutely did not happen at this particular traffic stop, which was the police car was parked 6 to 7 car lengths behind. They didn't walk up towards the vehicle. They stayed back behind their police van and where the police cars were. They had their guns pulled out. They did not ask for the driver's license and registration, and everything was just very strange. And also, 2 of the officers did not turn on their body-worn cameras either. And so then the defensive side was also saying, well, this was standard procedure. This was not a regular traffic stop. This was a felony stop. And they were told that there was a pointing incident. So you could see both sides of the argument. And also, towards the end, when both the plaintiff and defense attorneys were asking Officer M about more details, many several of the questions, Officer M was like, you'd have to ask the other officers about that because I didn't arrive at the incident until later. Like, you have to ask the other officers. He repeated that multiple times. And so by the time his testimony was done, we had more knowledge about what the police were thinking, what the protocols were, and now we're wondering, all right, what did the other police officers say?
So yeah, so one thing that's really weird about a trial, and I thought about this a lot. I've done now, I think more than 20. I've done more than 20 trials myself. Is what a weird experience it is for the jurors. Okay, I mean, because ultimately, and they're the ones who really have to make the decision here. They know nothing about the case. They probably don't want to be there. And yet now they're forced to sit there in court and listen to the evidence as it's presented by the lawyers, not the way that they would want the stuff presented, but the way the lawyers are basically kind of required to present, due following the rules of evidence, the court procedures. And it's really weird, okay? Because, what you're hearing is we take one witness at a time. And each witness can really only testify to what they really know about the case. They're not there. Witnesses generally aren't there to speculate about what happened. They're not there to guess. They're really testifying to the things that they personally observed or know. And so usually in trials, you get things kind of in a weird order where you hear a little bit here, and then later on with different witnesses, you hear another part of the story, and it's all kind of piecemeal until it hopefully all comes together by the end of the trial. But you're sitting there kind of listening, and there's things you want to know, but you just can't know until later on. So that's just kind of weird, and kind of like in this case, though, it sounds like what the plaintiffs did was set the scene, set the baseline, because pretty much I would think most trials that occur kind of have situations where there is a norm as to how things should go, and then it didn't happen that way, right? Something happened. Because look, if everything was done perfectly and normally, there probably wouldn't be a case, there probably wouldn't be a lawsuit, there probably wouldn't be a trial. So really, trials are about things where things went wrong somehow. And so what Arrow was describing, and it sounds like what the plaintiffs did here, was really try to set the scene, set how should a traffic stop normally go, to help the jury get that perspective. Because probably up until that moment, the jury probably had no idea about how a traffic stop should go. I mean, maybe they've been pulled over at some point for speeding or something like that, but they probably don't really know what's going on or how a police officer goes about a traffic stop. Most people probably don't. So now that is set. Okay, so now Arrow and Yolanda weren't there for the entire part of the trial, but they actually did get to see a lot of this trial ultimately. It just worked out that way. It just kind of worked out timing wise. Also, because this trial was actually kind of short as far as things go. A lot of times federal trials might go on for weeks. I've done multiple trials that went on for 3 or 4 weeks, including two trials that went on for even longer. This trial was basically, I think, like 3 or 4 days, if you don't count jury selection, and jury deliberations. So this was pretty short, so they got to see a lot of it. So why don't we pick up? Why don't we pick up now with, I think some other officers testified, but why don't we pick up with the plaintiffs, who I think testified towards the end of the case.
Yeah, so the next witness that we saw was Mrs. J.M., who was the wife and mother of the plaintiff's family in this case. And before her, I believe officers G and A had already testified, and unfortunately we missed that. So we began with the plaintiff's lawyers conducting a direct examination, and this was kind of establishing that she was from a family of police officers, but then this relates to her thought process going into the incident, because one of the things that the defense had said clued the officers into maybe this should be a felony stop rather than a normal traffic stop was the fact that after they turn on their lights and their alarms, the plaintiff's family's car didn't stop for about a mile. So from 35th to 39th Street, I believe, was the range of when they were driving, and 39th, or a little bit past 39th, is when they finally pulled over. And so the plaintiff's lawyers were asking, well, why did it take you so long to pull over? And Mrs. M said, basically, well, when the lights were initially on, they were on a portion of, I believe, an expressway or a highway where it wasn't completely safe to pull over. There was no shoulder, there was no like designated area to pull over. If she had pulled over when she was driving the car, it would have basically been just right on the road, if not a little bit on the dirt. And based on her conversations with her other family members who were police officers, she knew that traffic stops could be dangerous for police officers too. And she had also seen videos of police officers actually getting run over when they were exiting their cars on fast moving roads when they were trying to approach cars that they had pulled over. So out of consideration for the safety of her family as well as the safety of the officers behind her, she had waited until there was an exit with a shoulder to pull over. But unfortunately, that was actually quite a whiles off. So she had been driving for probably around a minute or two, just like long, probably longer than most people would wait to pull over with police officers. And this was something that the defense picked at too during the cross examination, which is like, well, this is all you heard from like internet videos and your family members, right? But did your police officer family members never tell you that you should pull over immediately when an officer is like behind you? Um, to which she kind of responded, well, they were like 5 to 7 car lengths behind me, so it took me a while even to realize that I was getting pulled over in the first place. So that kind of contributed to the long head time. And so that was the like first part that they were kind of going back and forth about. And the main part of her testimony was actually like her perception of the whole incident. And this part actually got quite emotional. So she was crying on the stand, and some of the jurors were actually crying too. And she talked about how basically it was kind of traumatizing for her to like she had done nothing wrong. Her husband had done nothing wrong. They were going at the speed limit, if not below, because she said she drives like an old lady. And um, so when she was getting pulled over, it came as a surprise to her, and she actually started recording at the time because she knew that she had seen so many other news stories and internet videos of people getting shot by the police based on just one wrong move. And so she thought to herself, well, if my family's getting shot today, I might as well have some documentation of it. But she quickly stopped recording when I believe the officers A and G had announced to their car over some kind of like megaphone to put their hands up to the ceiling of their car. And then this was when she got really scared because she knew that her children, who were 4 and 1, and they were in their like little safety like children's seats, they couldn't necessarily comply. Like the 1 year old was asleep, and the 4 year old couldn't even reach the ceiling. And according to the officer's testimony at one point, they had thought that the person shuffling in the back could have been someone concealing a weapon, but it was actually the 4 year old son just kind of like squirming around in his seat trying to figure out what's happening. And so after a few minutes of that, with their hands up in their car, Mrs. M was called out of the car to like slowly come out, put her hands up, and walk backwards to the police car without looking back once. And she just kind of described how terrified she was. If like one wrong movement, maybe like if she slipped and like fell or like tripped over something, that could have meant the incident would have gone really wrong. And so she was just terrified the entire time. And then she got handcuffed, and it was at this time that she was asking, like, why am I getting pulled over? Why am I getting handcuffed? Why are guns pointed at me and my family? And the officers had told her that they had heard that some car was on the loose after a shooting, and then she asked, well, does my car fit the description? Which Officer G, who we'll hear about the testimony of later, Officer G had told her, yeah, it was a white car. It was like a white sedan or something like that. And and Mrs. M was kind of indignant. She was like, "Well, no, that's not my car. Does my car fit the description?" And then uh, I believe Officer G had said yes. But then asked Mrs. M what color was her car, and then she was like, "It's gray." And yeah, the whole incident, she And we saw like video evidence of this too, body worn camera footage from other officers besides Officer A and G who didn't have their cameras on, of her just being really shaken up. At one point, their 4-year-old son had unbuckled himself while his parents were out of the car and actually tried to leave the car, which the parents are also terrified about. Like, what if their 4-year-old son just kind of hops out the car and gets shot at? Um, yeah, so the whole account was kind of very emotional for her and was pretty intense, yeah. And eventually it got to I believe the last line of questioning in the plaintiff's direct examination was about the emotional damage that she and her family suffered afterward. It was about like, well, as she testified, basically like she and her husband, their relationship has kind of fractured because like she believes that her husband might feel really bad about himself for basically not being able to be the man of the family after such a scary incident. She said that her son had withdrew on himself. We're about 4 years out from the initial incident now, so he's about 9 years old now, I believe. And she said that he, even though he's 9 years old and he's doing well in school, he has very few, if any, friends, and he doesn't like to talk about his feelings or anything with his parents. And actually, he talks to his little sister, who's about 4 or 5 years old now. When they hear sirens in the background when they're driving, he says, "Well, you better be still now, or you better be good, because officers might come get you and shoot at you." So, it was just kind of sad hearing that description. But then the defense kind of picked at it and went, "Well, you didn't really see a therapist after this. You didn't seek counseling for your son or your husband or any other member of your family, right?" And she was like, "No, we thought it was too painful to bring up, so we just decided not to go after counseling." And in fact, Mrs. M had been seeing a therapist before the incident for a completely unrelated occurrence when, after she had given birth, she experienced some trauma. And so the defense was asking her, well, are these feelings necessarily from the traffic stop, or are they maybe mixed up with feelings from when you were giving birth and experienced this trauma? And she actually stopped seeing her therapist very shortly after the incident, I believe. So the incident was December of 2020, and she stopped seeing her therapist in February of 2021. And the defense was like, well, why didn't you continue seeing her or continue seeing the therapist if what you say, if all these feelings that you experienced were really affecting you that much? And yeah, that was pretty much all of her testimony.
Okay, so two things about that, all that. First of all, I just want to be clear for everyone who's listening to this that first of all, this is all a public courtroom. Okay, so Yolanda, Arrow, they could have walked in, anyone could have walked into the courtroom and heard what they observed. And that's one thing that's really kind of important because first of all, just look, some of this stuff is obviously very personal, but ultimately, if you're going to go to court, if you're going to use the judicial system, it is public. And so that's something that sometimes people do have to take into consideration. Do they want to go through all of this to put their private issues, things like that, out into the public domain, basically? So and most times people aren't there in the background, but it was open courtroom, and Arrow and Yolanda were there, and they had totally had the right to be there for the trial. Um, but the big thing is kind of like, and it sounds like that's kind of what the defense was going to is, again, ultimately what a trial is about. There's a lot of times what they call like kind of two, sometimes it's even broken up in two different phases, what they call liability and damages. Liability, did the defense do something wrong? Did they actually, did they actually do something that was legally wrong? Either in a criminal case, a crime, or in civil cases, did they, breach a contract, or did they commit what's called a tort? When a tort is basically kind of an action that can cause damages and is improper, and that can be a basis for a lawsuit. And this is a kind of a tort, basically, a tort case. So liability is one thing, and then damages are the other, because you can commit a tort, but if you don't cause any damages, then either it becomes kind of pointless to bring the lawsuit, or you can win and it's kind of just a token amount. And you know what? You've actually, you might have even seen the news. There's even a few cases in the past few years where a celebrity has brought a lawsuit, won the tort, but basically won no damages or just nominal damages. And that's fine for the celebrity because they make enough money that they don't really care. But most people are bringing a lawsuit because they want more than just more than just a showing of liability. They actually want damages, and that's partially because you got to pay your attorneys generally to bring a lawsuit. And doing these kind of lawsuits can, you have to work out some arrangements with attorneys in order to bring, to cover the costs. So the issue in this case, and what makes this case a little different from your typical tort case, your typical kind of, case involving alleged police misconduct, is that there were no physical damages. Fortunately, this incident, a lot of stuff happened here that probably shouldn't have happened. But it did not go as badly as you probably heard about in some cases in the news. No one actually got shot. Okay, no one actually suffered physical damage. That's what makes this case a little different, and actually makes this case a little more complicated because you don't see the typical things you see in one of these cases. Typically, you see medical bills, right? You see that this person suffered massive damage, is not able to work again, and is going to have hospital bills or medical bills for the rest of their life. That's something you tend to see in a lot of these cases, but it's not the case here, which is, one of the issues that I think came up. Okay. Okay. So I think there was Yolanda's going to talk about one more witness, and then we'll move on to closings.
Yeah, so the last witness who was called was a witness for the defense, Officer G. And she was one of the officers who, like Officer M, showed up after the initial stop as kind of backup in this pointing incident. And the defense's direct examination of her was actually quite short. They just kind of talked about how, yeah, like sometimes dispatch gets the description of a vehicle wrong, and it was reasonable for Officers G and Officers A, from her perspective, to pull over a vehicle who might fit some of the description in the sense that it had damage, but might not fit other parts like the color or the make and model of the car. And they also asked her a little bit about like how she handled Mrs. M, because Officer G is who did a pat down search of Mrs. M when she was handcuffed next to the officers' cars. And the I think the defense was also trying to just further their the scene by saying that like none of the officers really treated them roughly outside of pointing the guns at them. He said, well, when Officer G, like when you were patting them down, you even picked up her stuff from the ground at the end, right? And then Officer G was like, yeah, I did. And then the defense was asking, like, did you, like, shove Mrs. M? Did you shove any of the other members of the family? Like, what does your body cam show? And yeah, there was not really any, like, rough physical treatment at all. So besides, like, the pointing and, like, having them kneel on the ground, there was not really any shoving or, like, any rough language. And Officer G and the other officers seemed pretty courteous, at least from the body cam footage. So then when the plaintiffs came to cross-examine Officer G, it became a lot more contentious. She actually, for a lot of the questions, for most of the questions, I'd say, she actually responded, I don't know, or I don't recall for a lot of them. So actually, when I believe the plaintiff's lawyer was asking Officer G about like her interactions with Mrs. M, even though Officer G had testified about basically the same questions to the defense lawyer about 5 or 10 minutes ago, she would say, "I don't recall, I don't know," and then she would have make basically the plaintiff's lawyer have to play back the body cam footage over and over again. And I think at one point for one question, the lawyer had to play the evidence like 2 or 3 times before she finally conceded to a yes. And it was all about these procedural things about like when you make a traffic stop, like a lot of the same questions that were asked to Officer M, really, about like what a standard stop looks like, whether she had a lot of information about the incident or not, and then also about the police report that Officers G and A filed afterwards that had some like characteristics of the car and like other details about the incident kind of checked off in different boxes on the report. And I remember at one point, the plaintiff's lawyer was asking Officer G, well, does this report have an area for the car description? And Officer G was like, I don't know. Even though the plaintiff's lawyer was pointing to a line that said description of the car or something like that. And then later down on the report, the plaintiff's lawyer pointed at a line about whether the offender or whether the people involved in the incident matched the offender description, and he was asking Officer G, well, what does offender mean in this instance? Does that mean a person? Does that mean a car? And then she was like, well, I don't know. It can be anything, anyone. Um, and then the plaintiff's lawyer was kind of incredulous, and he just kind of like took it further, and he's like, so anything that has a pulse can be an offender, just kind of being argumentative. And I think that question was actually struck down based on an objection from the defense's lawyers. But yeah, so she was actually being kind of difficult for the plaintiff's lawyers, but she definitely didn't say anything that I think detracted necessarily from the defense's case. It was a lot of just like stonewalling questions and contributing to more of the humanity of the defense's side, saying like, oh, they were actually kind of nice to the plaintiff's family after the initial part of the incident. But yeah.
So, yeah, I think was kind of, again, stepping back a little bit. When a trial happens, each side tries to put in witnesses, and, it'll be like one side will call the witness and one side, so it can flip around who calls the witness, who crosses, who puts on the direct, things like that. And so this trial looks like a lot of the officers were called by the plaintiffs in the plaintiff's case. And so by the time it got to the defense case, a lot of their witnesses had already testified, which is why they didn't really call a lot of their defense witnesses, because they already testified. Some of that really doesn't matter. It can matter in some circumstances. The big thing about the witnesses is that, like, a lot of times witnesses will have things that help one side and things that might help the other side, right? Because the truth is kind of murky, and every side's looking to pull out the things that kind of help their case. And that's really what is both sides are trying to do in a criminal trial or a civil trial. Elicit the information that they think will help set up their arguments at the end of a case. So a lot of times, like, a witness will testify, and it might even be things where, like, the jurors have no clue. Well, I don't understand why this witness is testifying. I don't understand why this is relevant. Well, it's because it's all going to come together at the closing, when the lawyers finally get to really put everything back together. So the pieces are all out there. It sounds like this case, there was witness testimony, there was body cam footage, there's probably some other things that are put in, and then it all gets in, and then both sides rest, meaning they say basically, that's it. We have put in our evidence. We're prepared to go on. And that's when we get to closing arguments, where the lawyers then get to pull it all together and put their case forward as to why the jury should agree with them. So, Errol, can you talk about the closings?
Yeah, right before the closing arguments were about to happen, the judge gave the jury a few instructions about what exactly to look for, and it included, like, you have to remember that the reason for stopping the car is not an issue in this case. Do not consider that, and then you have to consider, was there a need for the use of force? What was the actual extent of physical injury? And then was the family car like actually trying to flee from arrest? And she also stressed that you have to look at this whole entire situation from the perspective of a reasonable officer, and you also cannot consider the intention of the people, of the family in the car. Like, that's a separate issue. So you have to look at it as a reasonable police officer. Would any other reasonable police officer do the exact same things that the police in this case ended up doing? And then we got into closing arguments. So plaintiff went first, and I will say that the most striking thing about closing statements were that it was a lot more argumentative and forceful in terms of tone and language compared to the opening statement. The plaintiff attorney he glanced at his notes sometimes, but for most of the time he was talking directly to the jury, and he was making these very strong statements like, even if a police officer is afraid, that doesn't mean that they can do whatever they want. And, like, they're lying to your faces. their story. The police like cobbled up their story together on scene, and then they got their story straight at the end. Like they're lying, and then they're operating on hunches, not facts. They didn't get a single fact right. Like the description was a white sedan, but then they stopped a gray Nissan. What are they doing? And also, if if the person in the car was actually the murderer, like, would they actually drive under the speed limit? Would they pull over at a safe place for both themselves and the officer? And he was really trying to discredit everything that the defense said in their testimony. And also really leaned into Officer G's testimony when he was like, could have they could have stopped a giraffe or an elephant. So that was really interesting. Oh, and then at the end, throughout this whole case, they the plaintiff never mentioned a specific number for the amount of money that they were going for. And so that was kept all the way up until the end, where in the plaintiff's closing statement, he was like, we're asking for $1.5 million, which sounds like a lot, but if you were to pay, Mrs. M $100 per day for the rest of her life for having to live with this trauma, this emotional trauma, that's how much it would amount to. So the number was revealed at the end. And then for defense's closing statement, it was actually shorter than I had anticipated. Their main two arguments were that the police were doing everything that they should be doing, protocol wise, and they had reason to suspect that the car was involved in the murder because some of the description matched. And then also, the second point was that the officers did understand when they were saying, I'm sorry, in like the footage. They did apologize to Mrs. M, and defense just stressed again that he was not apologizing for anything that the police themselves did wrong. He was apologizing for the fact that he knows for any innocent family this is a stressful thing to go through, and it's just unfortunate that this had to happen to his family. Uh, yeah.
Now, let me just talk a little bit about juries, a little bit, just before Yolanda kind of explains kind of what happened after closing arguments. So, again, as Era was saying, a judge will provide jury instructions to the jury about what the law is and what they have to decide. So pretty much for every kind of case, the plaintiff will bring claims or the government will bring criminal charges, but ultimately there are certain elements that the jury has to consider and basically see, like, did the plaintiff or whoever has the burden of proof meet that burden of proof? And again, civil cases generally preponderance evidence, criminal cases is beyond a reasonable doubt. And so a lot of that is the judge will kind of set that out for the jury so they understand kind of what they actually have to decide. And a big thing in trials is that the jury, it can be different for civil cases, but generally speaking, juries have to be unanimous in terms of their verdict. And that means that once the jury is done, all the trial is done, that's when the jury's work really begins. Because jurors are not allowed to talk about a case while the trial is happening. Because that would kind of lead to them prejudging things and kind of making up their mind. So they really are supposed to keep an open mind all the way through closing arguments. And then they're supposed to go back into the jury room and then basically start reviewing the evidence, talking about the case amongst themselves, and determining if they can reach a unanimous verdict. So this case, I think the jury got the case, I think, on Thursday, and they continued deliberating into Friday, so into a second day. And so, Yolanda, can you explain kind of what happened, what you saw, again, just based on what you saw in court?
Yeah, so it was quite a lot of waiting. I think it was maybe like 2 or 3 o'clock when the jury got the case on Thursday, and they deliberated all throughout the afternoon. I'm not sure when they left because I know the judge gave them the option to leave either at the normal time of 4:30 or to stay until 6 p.m. when the courthouse closes. So I'm not super sure if they stayed all the way until 6 p.m., but they went all the way into Friday, and I believe this was around 12 p.m. maybe, they had sent a note to the judge asking about some of the evidence. I think either they were confused about where the evidence was located on the hard drive that was provided to them, or sorry, the flash drive, or maybe they were having a little bit of trouble finding the relevant parts of this one exhibit because it was an hour-long recording, and the recording was also pretty fuzzy based on my memory of it. So, yeah, so I think the judge and kind of went with the defense and was like, yeah, I'll just give them another copy of Exhibit 25 or whatever it was. And then I think about an hour or two later, around 2 p.m., the jury had come back with another note saying that they had found for the defense on the claim about the illegal search, but they were deadlocked on the two claims about excessive force. And so after a little bit more shuffling around, the judge had asked the jury to fill out the verdict form and to come back and basically deliver their verdict. And yeah, I think both sides did not seem super satisfied with that, and I can imagine why. It seemed like kind of or it wasn't a long trial, I know, but it was still a lot of work, I'm sure, that went into it, and I'm sure no one would want to have to go through all of that again. So at the end, the judge had declared a mistrial on the two count or the two claims about excessive force, and then ordered a status report to be delivered from the two parties on April 3rd, I believe. So that's a few weeks from now.
Yeah, so basically, look, the system, the system here is disappointing to kind of come back effectively with a hung jury, right? Effectively, the jury couldn't reach a resolution, a unanimous verdict on the excessive force charges, excessive force claims. And basically, it kind of means that the trial didn't, I mean, basically, it could be redone. If there's a hung jury, basically the plaintiff could decide that, okay, we want a new trial. We want to do it again and try again. Uh, what's probably realistically going to happen is both sides are probably going to basically try to have settlement discussions and see if they can resolve the case. Because in some ways, what happened was, we knew from, again, this jury did not know this, but, as the public docket shows, before trial, they couldn't reach a settlement because the parties were too far apart. Now they know that now both sides have a better sense of how this case actually played out, and they have a sense of how, 8 members of the community view the case. And what they now know is that basically 8 members of the case, just like they couldn't figure out how to resolve the case, 8 members of the jury, the 8 jurors couldn't figure out how to resolve the case, not unanimously. So this case might go on to another trial. They might try to work out a settlement. And at this point in time, we don't know what that's going to be. Ultimately, Arrow and Yolanda got to see a lot of things that I think many law students, many young lawyers don't see or haven't seen. Because they got to see kind of how a lot of this process actually unfolds. And I think it's very different than what you see on TV or in the movies. There's a lot more back and forth. It's a lot slower. And, it's a lot of things that kind of build up over time, right? As I think Yolanda and Errol mentioned, kind of the opening statements are one thing, but really it's kind of the closing. It really doesn't all come together to the closing arguments. And that's where really it's like, oh, okay, now everything makes sense. And now you really see where things are coming. And even where some things finally get said that didn't come up earlier. So, so first of all, I'm very glad that they got a chance to see this in court. And I really do hope that anyone who's listening to this or watching this and is interested in going to law takes advantage of similar opportunities to go to court yourself. I highly encourage people just to go check especially a lot of the federal courts, they have daily calendars that are available online. You can just go check them out and just go to court and just go do what we did. Just kind of go pop around the building and see, oh, this looks interesting, and stick around. And then, you can learn a lot just by doing that. Again, I highly encourage any of you who are listening or watching who are thinking about going to law or already in law school or already lawyers yourself. If you haven't gone to court, please do so. I mean, you're going to learn so much. Yolanda, Arrow, they got to see so much, they learned a lot themselves. This is how I got started myself. It's just a really great opportunity to really see and pick up things. So, thanks again for listening or watching. Thanks, Yolanda and Arrow, for being here and for giving us your thoughts on the trial. And please reach out if you have any questions. Thanks a lot, everyone.
Thank you.